Welcome to today's webinar, States Respond to Untested Sexual Assault Evidence, the Legislative Response, brought to you by NCSL. All lines have been placed on a listen-only mode to provide favorable sound quality during today's presentation. It is now my pleasure to turn the floor over to your host, Richard Williams. Richard, the floor is yours.
Hello, everybody. I'd like to thank everyone again for their patience and for joining us today for this NCSL webinar. The title again is Untested Sexual Assault Evidence, the Legislative Response. As Mike said, my name is Rich Williams. I'm a policy specialist here in our criminal justice program, and I'll be the moderator. I'll do a short presentation, and I'll just be the voice in your head agitating you for the next hour or so. Okay, so we are able to bring you this webinar through NCSL Criminal Justice Program's partnership with the Laura and John Arnold Foundation. Through that partnership, we've been able to support a good deal of forensic science work, which is another reason we're having this webinar today, is to announce the official launch of our forensic science laws database. And there's a picture of it now up on your slide here. That is the home page of it. You can find it either by Googling or just binging NCSL Forensic Laws Database. If you happen to be on our website, we have these things called Go IDs. You can put right in the search box 21808. That's the number noted over here, and that'll bring you right to this home page. Once you're there, you have the option to search by state or by policy, and you can find there'll be 9 different forensic science policies addressed in this search by policy section right here. You click on that, and it'll give you a list. And also here you can find 50 state pages in the District of Columbia, so you can find the forensic science laws addressed across each of the different topics in there. And we cover different things in there, from DNA arrestee laws to post-conviction testing to accreditation requirements for forensic laboratories. And then we have another section in there on forensic biology backlogs and untested sexual assault evidence, which is the issue that we chose to highlight for this webinar today. And the reason we chose to highlight it is because it's still it's a growing issue, and it's growing in interest definitely across the country. We've been getting a lot of questions on it. I'd say over the last year, the interest has really started to pick up, there's a lot of people still in the process of figuring out what the exact right way to approach these issues are. And so I and NCSL are really grateful to have 2 people who are working hard on this issue with us to present on the webinar today. We have Dr. Rebecca Campbell and California Assembly Member Nancy Skinner. So I just want to up front say thank you for both of you for giving your time. I think it'll be a really valuable resource for us today and also going forward. Okay, so I would like to now just give you a brief overview of what you're going to hear from us today. The first speaker that will go is Dr. Rebecca Campbell. She's a professor of psychology at Michigan State University. She's worked extensively on the Detroit Sexual Assault Kit project, and is currently working with the National Institute of Justice to produce a report overviewing the findings that her and the team that she's working with, the lessons that they've learned from that process. Then you'll hear from me, and I'll give you just a brief overview of what current state enactments are out there addressing sexual assault evidence. And finally, you'll hear from California Assembly Member Nancy Skinner, who's the chair of the Assembly Committee on Budget. She's also the sponsor of a bill addressing sexual assault evidence in California that's currently with the governor. And she'll share with you her interest in the issue and California's experience with sexual assault evidence issues, and be able to provide some of the political realities of that for you. And then at the end, there'll be a brief portion for question and answer. So if you have a question that occurs to you during the presentations, please feel free to type those into the little box and send them on over to us. Okay, so without further ado, I'm going to turn the presentation over to Dr. Rebecca Campbell. And let me... Rebecca, please, the floor is yours. Rebecca, are you there? We appear to have lost Rebecca for a second. Hold on for a moment.
I am here.
Hey, sorry, did the mute button get you?
No, don't ask. I'm here. I'm ready. Is the floor mine now?
Yes, it is yours.
Okay. Good afternoon, everyone. Thank you so much for your patience with our technical challenges. My name is Rebecca Campbell, as Rich said. I'm a professor of psychology at Michigan State University, and I'm pleased to have the opportunity to talk to you today about the issue of untested rape kits, which, as you know, is becoming a growing national problem. In the short time that I have with you today, I want to talk a little bit about just what is a rape kit 101, and then I want to take you through some key issues that we've talked about and been wrestling with in Detroit. First off, how do you know if your community has a problem with untested rape kits? And then if you do, how did it happen? Why did it happen? What do we know about the underlying causes of this problem? And then what have we been able to develop in Michigan in terms of solutions? And we'll actually bump Q&A to the very end, but I look forward to hearing your questions and comments about this. So first off, what is a rape kit? As many of you know, that this is actually part of the medical forensic exam, which is generally done after a sexual assault within the first 24 to 72 hours. And at that exam, a healthcare practitioner can collect the rape kit, which is going to consist of oral, vaginal, and anal swabs, other parts of the victim's body that might have been touched or otherwise have contact with. So the neck, the breasts are common areas that are swabbed. Hair samples will be taken through both combing and plucking, and then any injuries or other issues that need to be documented with photography will be photographed. Now, this is a very difficult process for victims. The exam itself usually takes 2 to 3 hours, and victims often have to wait 4 to 8 hours to have the exam because these are traditionally done in hospital emergency departments. This is often not an emergent life-threatening situation, and so they wait. So victims cannot eat, drink, or go to the bathroom, shower, or change, or do anything human while they're waiting for the exam. So it's not a surprise then that in our research we find very consistently that rape victims describe the exam and the sexual assault kit process as being re-raped, as violating, as degrading, and humiliating. But they often endure it and go through it because they feel like this is what they have to do to be able to engage the criminal justice system and try to move forward with prosecution. So after the exam, that rape kit that the healthcare provider has collected is evidence, and it is supposed to be picked up by police, i.e. taken into custody, and they're supposed to take it to a crime lab for testing. Now, at the crime lab, what are they testing for? Well, most notably DNA. And we can certainly see how in the context of stranger assaults that DNA would be very critical. If there's a profile extracted, it could be loaded into CODIS, the national database for DNA offenders, and there could be a match, giving the investigators a very promising investigative lead as to who the assailant might be. DNA can also be helpful in non-stranger sexual assaults to confirm that there was sexual contact between the perpetrator and the victim, and that rebut claims, I never touched her. Now, in all types of sexual assault, DNA testing can be very helpful for identifying serial rapists. Now, certainly that's easy to imagine in stranger sexual assaults, but it can also be very helpful in non-stranger assaults. So consider the following example. In case A, police say, we're not going to test this kit because the victim knows the perpetrator. There's no point in testing it. Then in case B, the police say, no point in testing this one. The victim knows the assailant. Case C, we don't need to test that one. She knows who it is. But if you tested the kits in case A and B and C, they might all match, indicating a pattern of serial offending. So DNA testing in sexual assault can be very useful also for identifying patterns of serial rape whereby the offender is sequentially sexually assaulting individuals that he knows. And finally, of course, DNA is very critical for exonerating individuals who have been wrongly accused of sexual assault. Sorry for those of you, I don't think the screen advanced quite right, but that was the main point there. So there's many different reasons to test a rape kit, but the problem is that this is not happening consistently in the United States. Thousands of rape kits are not being tested, And conservative estimates suggest that there's probably in the neighborhood of about 200,000 or so untested rape kits and police property throughout the United States. The advocacy group and the backlog has been tracking which cities have kits, and you can see that this is indeed a growing national problem. Before I go any further, I want to pause, though, and clarify a bit of language and terminology, because at the federal level, there's different terms used to refer to different problems regarding sexual assault kits. So the Department of Justice uses the term backlog and backlog kits very specifically to mean kits that were submitted by the police to a forensic laboratory for testing, but the kit is still waiting for testing at the lab. So when we think about the steps that a kit goes through from the time the medical provider collects it to when the kit is tested at the lab, backlog represents a specific problem of when a kit is not tested, when the kit is still waiting at the laboratory for testing. This is very different than the problem of an untested, or more specifically, an unsubmitted kit. This is when the police picked up the kit, but they did not take it to the laboratory for testing. So the problem is at a different juncture in the process. So these are slightly different problems. Is the problem that the kit's at the lab and it's waiting for testing and the lab doesn't have sufficient resources to do the testing in a timely way? Or is the problem that the police aren't submitting kits in the first place? So different problems, different solutions. So from this point forward in the webinar, I want to focus on the problem of unsubmitted kits. So the instance where police have made a decision not to submit a kit for testing. And specifically, what I want to talk about in the remainder of my time with you today is how different communities might go about trying to discover whether they have a problem. Do you have large numbers of untested sexual assault kits in your community? Why does this happen? What do we know about the underlying causes, or another way to put that? What do we know about the risk factors for developing this problem? And then third, I want to share some preliminary ideas about solutions that we've identified in Detroit that might be useful to other jurisdictions. And again, I will be drawing upon the research I've done in Detroit to inform the rest of this presentation. So first off, discovery. How do you know you have a problem? How do you know that your community has large numbers of untested sexual assault kits? Well, generally, so far, communities that have this problem have figured out by accident. So for example, in August 2009, representatives from the Wayne County Prosecutor's Office, the Michigan State Police, were invited to tour a Detroit Police Department property storage facility. It was part of just a general audit of trying to figure out, hey, what should we be doing with police property? What should we be doing with storage? Here's what happened. This is a quote from one of the prosecutors who was on that tour. He said, we're walking through, and I see these like steel shelving units with boxes, and I say, what are those? And they said, those are rape kits. And I said, rape kits? What are all those rape kits doing here? I estimated 10,000 or more. And I asked, are they tested or untested? And the officer said, I don't know. Go from something like that to something like this without too much time passing. Wayne County Prosecutor Kim Worthy wants an independent investigation into what she says may be thousands of kits holding evidence of possible sexual assaults that were found in a Detroit Police Department storage facility. So it was an accident in Detroit. It's been an accident in other jurisdictions. So building on this, what can communities start to do now to proactively check for this problem? First and foremost, you got to get into police property. You have to do an audit of police property. You need to see what is actually happening in your jurisdiction, what is being stored. Now, in the walkthrough of police property, one of the key things that we're finding is important to pay attention to is what are the procedures for how rape kits are being stored? Are they being stored together, like on those, in the boxes on the steel shelves as they were in Detroit, or are they scattered throughout property? So imagine, for example, a shelf with a whole bunch of bins on it. You know, imagine like bins from Target or something. So you pull the bin out, and inside the bin, there could be a rape kit, some ballistics, all kinds of different evidence from different scenes, all appropriately labeled and tagged, but it's all together in this bin. And then in the next bin, there's a couple more rape kits and so on and so forth. We're finding in both Detroit and other jurisdictions that if the storage procedures for rape kits are such that they are dispersed all throughout the different bins and property, it is harder to get a handle on the problem of untested rape kits because you don't see them. They're all scattered. If they're all grouped together, it provides a very simple, straightforward, immediate way of keeping an eye on how many kits do we have and are they starting to accumulate. Other issues that we're seeing are important to think about in diagnosing this problem is how the underlying IT is set up. So for example, Detroit did have a record, computerized property records, but you know what? They didn't talk to, so to speak, the testing records. So there was no way to interface the property records and the testing records to have any idea of all the rape kits that have been entered into property, how many were tested. There was no way to link those two systems. And as I've been consulting with other communities throughout the United States with this problem, I'm seeing this happen over and over again, where the IT was set up in such a way that it was not possible to bring the property storage system together with testing. Now, the other problem to keep in mind here is that even if you can bring these systems together and a community is aware that it has large numbers of kits, what can you do to facilitate disclosure? Because nobody wants to be the next Detroit, the next Memphis, the next Cleveland, the next San Antonio, the next San Francisco, and on and on. So we need to be thinking about how do we make resources available to jurisdictions with this problem so that they feel like they can come forward and admit they have a problem with untested kits. So some resources I just wanted to bring to your attention for this issue of the discovery and the diagnosing of the problem. As Rich said, the Detroit report will be coming out in early 2015. We have a step-by-step guide for conducting a census and going through police property and figuring out what you have. It's also a good idea to connect to other cities that have had this problem, and I've listed several there on the screen, and to connect to national organizations that are providing consultation and technical assistance on this issue. Okay, so moving on, I want to talk a little bit also about what we've been able to find out regarding the underlying causes. Why did this happen? Why do communities have large numbers of untested sexual assault kits? So in our work on this in Detroit, we took a systemic approach. And by systemic, I mean this is a problem rooted in long-standing relationships within and between organizations. You don't get this problem because one person didn't do his or her job. It's just not that simple. So we want to think about the system of interconnected organizations that are supposed to be processing rape kits. So indeed, the police are supposed to transport a kit to the crime lab for testing. But those two organizations are part of a broader criminal justice system that also involves the prosecutors. So we need to understand the relationships between all three components of the criminal justice system. And of course, there will be no rape kit to test if the medical system doesn't conduct the exam and collect the kit. So we need to understand what the relationship is between the medical community and the legal community. None of this happens if the survivor doesn't come forward to seek an exam and to report the assault. And in that process, it is quite likely that the survivor will need advocacy, support for themselves going through this process. And then community-based advocacy in particular may also be involved in efforts for social change to agitate a little bit these other systems to say, hey, what's happening in this particular case? So what we did in Detroit was try to take a systemic perspective to understand what was happening within and between all of these different organizations over the 30 years that the kits were accumulating in Detroit. So to that end, I'm going to share with you just some snapshot findings. First, starting within the police, because it was their responsibility to submit the kits and they didn't. What was the key reason why they didn't? Straight up, they did not believe victims and they had very victim-blaming attitudes towards sexual assault survivors. So when we went through the police reports and we interviewed them, this is what we heard over and over again. This is what was written over and over again in the police reports. It's not really rape, it's a deal gone bad, implying that she's a prostitute. You know, what did she expect being with him? He's a known felon. She's lying to cover it up. So over and over again in our interviews and in the police reports themselves, the police were basically saying, you know, this isn't a real rape. There's no point in testing it. And in Detroit, there was no training, no education, no supervision around the issues of sexual assault policy, sexual assault criminal procedure, that could have checked and balanced any of these things. So these behaviors and beliefs went unchallenged for 30 years. Another key factor that we found as a risk factor for the development of untested kits is that there was no policy or protocol in Detroit regarding kit testing. It was literally up to whoever to decide whether a kit would be tested. Sometimes it was the police decision. Sometimes the prosecutors would intervene to say, hey, we need that particular kit tested. But there was no policy saying, this is what you ought to do. This is what must be done. So the decision was largely left to the individual discretion of police officers who, see prior slide, often had very negative and stereotypical beliefs about rape victims. And in that context, more often than not, they decided not to submit a kit. Factor we identified in Detroit that we're also seeing in other jurisdictions with this problem is that the organizations involved went through drastic reductions in their personnel over time. So for example, the Detroit Police Department Crime Lab had 2 DNA scientists. And if that sounds low to you, it is low. It's objectively low. In other cities with comparable crime rates, it would be typical to have between 8 and 14 DNA scientists, and they had 2. The sex crimes unit in Detroit went through a 50% reduction in their staffing, not once, but twice over the 30 years that these kits were accumulating. The prosecutor's office also went through a steady decline in the number of assistant prosecuting attorneys, and they had no specialized unit. So their warranting unit was a sort of a come one, come all, first come, first served basis of trying to process cases. A key risk factor we found was that there were numerous changes in leadership and supervision in all of these organizations, but most profoundly in the police department. Over the 20 years where the bulk of the kits were piling up, the Detroit Police Department had 9 different police chiefs, 5 of whom served less than 3 years. And the average tenure for a DPD police chief is 2.2 years. By comparison, when we look at national norms, it's much higher. In metropolitan cities, it's averaged between 3.5 to 4.5 years, and in jurisdictions of over 500, the average tenure is 5 years. So the police chief in Detroit was turning over about twice as fast as it would be expected in other cities of comparable size. Now, the problem here is that the leadership often trickles all the way down to the supervising unit of the sex crimes unit. So about every 2 years, they had a new supervisor. So the idea that you could detect a problem, do something about the problem, implement a change strategy in 2 years before you're out the door, it's not tenable. So there was chronic instability in leadership that allowed a problem to develop and fester and go unchecked for years and years. Now, stepping outside of the legal system, let's bring in what we know from the medical system. Many of you are familiar with sexual assault nurse examiner programs, which are noted by the Department of Justice as best practice for post-assault care. Well, Detroit didn't have one until 2006. That's late. Many same programs developed in the 1980s, 1990s, early 2000s. This was 2006. So for decades, the rape kits were conducted in hospital emergency departments in Detroit. It was unclear whether they were any good. The doctors had very little interest in doing these kits and would often hand them off to the police saying, yeah, good luck with it. I don't know if it's going to be helpful to you. So the message from the medical system to the police was one of indifference at best or skepticism at worst. Now, looping in advocacy, the other thing that we found was a risk factor in Detroit, and I'm seeing in other jurisdictions, is that there wasn't a very strong presence of community-based advocacy services. Indeed, in Detroit, there was one advocate, one, for a city of that size and that crime rate. One person is not going to be capable of providing the direct support to survivors and then being able to challenge what's happening in these systems. So when you take this as a whole in terms of the systemic breakdowns that were happening in Detroit, where does it leave survivors? Pretty much on their own. And we're seeing very similar patterns in other cities that have this problem of difficulty having sufficient staffing, sufficient resources, training, policies, community services, and a lot of very, very strained relationships between these organizations. So I encourage jurisdictions to, when they're taking stock of this problem, to ask themselves, where are you on these key issues that you see on your screen, as these are key risk factors for the development of this problem and its continuation over years. A couple of key resources to bring to your attention, and again, you'll get copies of this, so don't try to write down those ridiculous addresses. There's a really couple good training videos that are available for free on YouTube that provide training for law enforcement to challenge those underlying beliefs about victims and rape kit testing. And Violence Against Women International is also a very trusted resource for webinars, training, and conferences on this issue and in general sexual assault investigations. So I want to wrap up by talking a little bit about solutions. If this is a community that has large numbers of untested rape kits, what should you do? First and foremost, you need a multidisciplinary approach. Even if this problem originated in the legal system, in the law enforcement agency, as I just showed you, it's a systemic breakdown most likely. You got to get everyone to the table. Law enforcement, prosecution, the forensic community, medical nursing, advocacy, both the community-based rape crisis centers as well as the systems-based advocates in police departments and prosecutors' office, as well as government officials at the local, county, and state level to sit down and work through this as a team. Each discipline is going to have a slightly different perspective on the problem, and that's good. Diversity of perspectives is going to help bring about a better long-term solution. Now, this multidisciplinary team now has a very, very big set of issues to tackle. You're going to have to develop a testing plan. You have to develop a trauma-informed victim notification protocol. You're going to have to go back and tell the victims what happened, give them the testing information, and try to re-engage them in the system. There's going to be a need for developing short-term and long-term staffing for testing, investigation, prosecution, and advocacy, which will require funding. And very likely there's going to need to be both policy and legislative changes to address the current problem and to prevent it from happening in the future. In terms of resources to point you to for this issue, I recommend, again, keep an eye out for the Detroit and Houston research projects, connecting with other cities that have had to go through these steps, as well as national organizations. So with that, I'm going to turn it over, I believe, to Rich, who's going to take you through the next part of today's webinar. Thank you for your time.
Thank you, Dr. Campbell. We really appreciate that, and that's a really good foundation for understanding sort of the whole process of what goes on with sexual assault evidence collection and where the challenges are for state processes to deal with and address it effectively. So I will hopefully be able to build on that, and I will be talking to you about state laws that have been enacted across the 50 states, addressing the very issues that Dr. Campbell was talking about. And I'd like to note in the beginning, I'm going to be talking about states and the actions they've taken. The citations for all of those can be found in the forensic laws database that I pointed you to at the beginning of the webinar. So I will take that opportunity for a cheap plug and keep going. So the way that I've organized this information, it was a way that I found helpful to learn the issue myself. And I sort of laid out a roadmap here for you for how I went about it, and hopefully that'll help you learn what the laws are as well. And so the two main ways that I look at laws that have been enacted so far by state legislatures addressing this issue are either aimed at addressing the current found untested evidence, like in Detroit that Dr. Campbell mentioned, or improving the overall system, improving the process, how agencies talk to each other, how they communicate with victims, the kind of training that are received by both the people who are collecting the evidence and law enforcement who are on the front line dealing with people who allege being victims of sexual assault. So to start, I'd like to talk about these are the states that have done significant countings of untested sexual assault evidence in police custody. And I've broken it out in this way. In the left-hand column, those are all states that have passed statute requiring agencies in their state to do counts of their untested evidence. So usually how they work, and I have the names of the agencies listed under here, these coordinating agencies will work with every local law enforcement department in the state to get a number from them about their untested sexual assault evidence. Then these groups will submit reports to the legislature and the governor or specific committees within the legislature. The reporting requirements of them that way kind of vary. But I've also listed next to them the dates to which these reports should be submitted. The most recent one that has come in has been Tennessee, and that was earlier this month, and I think they found that they had a little over 9,000 untested kits across the state. I'd also like to point out that of those 5, the 3 on the bottom focus specifically just on counting. Illinois and Colorado laws that were passed, I want to say, in 2010 and last year, actually also provide for charging the state agencies to come up with a plan for testing the kits once they're identified, for the collection and testing of them once they're identified. And I'll talk about the specifics of that in a minute. But then I also wanted to mention the 2 states on the right, just to show a diversity of how states are addressing counting their untested sexual assault kits. I know that the Attorney General's office in Ohio has done a lot of work on sexual assault issues, and while I don't believe as formalized as the counts in the other states, has done a lot of work on figuring out what their actual amount of untested sexual assault kits are there. And Hawaii, I want to point out, it was through a legislative resolution, so not a law, to direct their Attorney General to come up with an effective process and identify what their current process was for tracking sexual assault evidence. And as part of that, they issued a report that goes into detail discussing about the benefits of testing all evidence versus some evidence, which again I'll talk about in a minute. But I just wanted to show you this as the different way that states are handling identifying and counting and going and taking the next step to test their untested sexual assault evidence. So in addition, I thought another thing that was interesting about these laws is states that have given a little bit of funding towards the process of testing and for what specific purposes that the money's been given. So Colorado gave a little bit over $6 million after charging I want to say the Department of Public Safety with coming up with a plan to test their evidence. And so that money was given just for the broad process of going about testing. They also included a provision in the law that allowed the department to seek additional funding should it be needed to address and test any remaining kits. Also, and Dr. Campbell probably knows more about this than I do, but as part of the funding that they've been using to test sexual assault kits in Detroit, the Michigan legislature gave I'm missing a zero there, but they gave $4 million to help conduct testing there as well. They also provided a provision that asked their Attorney General to come up with a work plan anticipating litigation that resulted from testing their kits and to propose what the amount that would be necessary to test those kits. And then also, just as another example, Illinois, while they didn't give a specific dollar amount in their legislation, when they charged their executive director of the state police with figuring out a plan to test their backlog kits, they asked that included in that plan be a funding request tied specifically to the actions that they would need to address it. And I want to touch on a closely related issue just sort of quickly here. Statutes of limitations is becoming something that's affecting states as they try to figure out and look through their untested sexual assault evidence. So I've seen, and Dr. Campbell mentioned in Detroit, that many jurisdictions, as they're going through, are finding kits, and it commonly is 25 to 30 years old. So with sexual assault So with statutes of limitations, after a certain amount of time passes, the crime can't be prosecuted. And so the number of years that have to pass is different from state to state, and it's different for crime to crime. But for example, Colorado has a 10-year statute of limitations on sexual assault, and Ohio has a 20-year statute of limitations on rape. And I know that those have been factors for them as they go about prioritizing the kits that they want to get tested first that they found in their untested evidence. And even in Colorado's legislation, the plan that the agencies had to come up with to test the evidence had to factor in those kind of time prioritization considerations. Okay, well that sort of does it for the portion addressing state laws that look at the current mass or finding of untested kits, and we're now going to switch to the type that are addressing or that are aimed at improving the system-wide collection and testing of sexual assault evidence. And so one of the first thing I want to start with is time limits, and mostly because I think it does a good job of piggybacking on Dr. Campbell showing how the different agencies work together and the communication there. And I think that's the aim of these type of bills. So it's usually a number of days where one agency has to either pick up or drop off an evidence kit at the next step in the process. And for example, Michigan has a law that gives police 14 days to pick up a completed medical exam from a facility once they've been notified. And then the police have an additional 14 days to bring it to the lab. And then once the lab has it, they're given 90 days to complete the testing. And I'll just point out also in Illinois and Colorado have similar laws for the police to get the evidence to their new evidence to a forensic laboratory for testing. In Illinois, it's 10 days, and in Colorado, it's 21 days. There are some other laws out there that have similar responsibility assuming qualities to them, but not the time limits to go with them. So, for example, Arkansas has a law that talks about how once police are notified that a victim of sexual assault would like to have their evidence tested, the police show up, and once they show up and collect the item, then they assume responsibility for the investigation and the evidence. So, and moving on, I'd like to now just address, and these things I think kind of melt into one another, oversight and protocols for untested sexual assault evidence. And these things are all aimed at helping the right hand know what the left hand is doing. Some of the communication issues Dr. Campbell talked about, I believe these are aimed at, and they target different steps of the process from evidence collection to what you do with decisions about evidence to test. And so for those different examples, at the front end of the system, this year West Virginia enacted a law that created the Sexual Assault Forensic Examination Commission. And their duty is to develop mandatory statewide protocols for conducting exams, and then also overseeing that process and ensure that they're done uniformly throughout the state. And Indiana charged similar responsibilities to their superintendent of state police. And so those are protocols, and those are laws focused on shoring up protocols at the front end where the evidence is actually collected. And then I'd like to talk a little bit about also some things that have happened further down the line. And it was brought to my attention today that it was in the news here in Denver addressing Colorado's law that went into effect last year. So part of that law charged the executive director of the Department of Public Safety to come up with a plan to test and analyze evidence, and part of that work was done through a committee group that had different representatives of victims advocates, police, lab personnel. It was a very widely represented group, and so part of that and part of what I had seen in the news yesterday was about the benefits of testing all evidence versus testing versus developing protocols to figure out which is the appropriate evidence to test. And it's some of the stuff that Dr. Campbell talked about before. So in their protocols that they came up with, they will not test the evidence if the victim does not wish to pursue charges. if it's been otherwise corroborated that the report had been false, if the statute of limitations has passed, and if some of the procedures were sealed by the court. And so it can be challenging to understand and weigh what the pros and cons as seen by different state entities are for these arguments. But I wanted to point out back to that Hawaii resolution, because they did produce a report that had a really good synopsis of what the arguments are on either side of developing protocols that are more inclusive or more strict about testing. And both of them, both in Colorado and Hawaii, one of the big considerations they pointed to was cost and having the money and trying to figure out what the most effective or or prioritizing the best evidence with the amount of resources that are available. Moving on, another big issue that gets brought up in state legislation is improving the communication with victims about the status of the evidence that they submit. And currently, 10 states have laws that address these provisions in some capacity. So really, the main thing that it does is it usually either gives the victim's rights or puts the onus on the law enforcement agency to communicate with them about certain milestones about their case, and I've listed those there on the slide. One can just be notifying the victims at the beginning what their rights are, whether there was enough DNA evidence in their kit to produce a profile, whether the profile into the database matches that are made, and then a big one I think is the law enforcement notifying the victim before evidence is disposed of. And a few states have provisions allowing the victim to appeal a decision to destroy the evidence, so that they can be heard if they feel like their case should still be pursued. Another aspect of that I wanted to point out that I saw in the Colorado law that I thought was interesting is that their law provides that if a victim requests that evidence be collected, it must be. So the decision can't be made by law enforcement or an examiner not to collect the evidence. And also that law enforcement and examiners are not in any way allowed to discourage victims from having evidence collected if they want to. And just if you're looking for a recent example of a state that's put into place these victim-centered communication laws about sexual assault, Utah passed a bill this year that's pretty comprehensive and touches on most of the issues that I have listed up there. And the last thing I want to mention is just the efforts that states have put forward to training, and just two quick examples of those. For examiners, Illinois' law required the Department of State Police to develop a sexual assault evidence collection program to train hospital personnel in collecting. And it talks a little bit about, again, what Dr. Kimball was talking about with the sexual assault nurse examiners. And we have more information on that. If you're interested, please contact me. And then also for law enforcement, I wanted to point out there's a number of states out there that have things to include in basic police training. For example, Arkansas, as part of regular police training, requires that they work on, or they be trained in sexual assault issues, so like the kind of resources that are available to sexual assault victims, communicating with sexual assault victims, common concerns generally, so that they're better trained to navigate those issues when they're faced with them. Okay, so that does it for my portion. And so, again, just a reminder, if you have questions as we go through, please submit them on the web form and we can get to them at the end. And also, any of the laws that I mentioned during that, you can find them, again, on our forensic laws database that you can find on our website. And so, moving on, I'd like to say welcome to and thank you for participating to Assembly Member Nancy Skinner from California. I'm grateful to have her today. She's worked on sexual assault evidence issues this year with AB 1517, a bill that's currently on the governor's desk. And so, Assemblymember Skinner, I can't wait to hear about your experience in California, and the floor is yours.
Thanks so much. And I will be dependent on someone else moving my slides, as for some reason my Apple computer wouldn't allow me to log in a way that I could manipulate them. So as you see on the first visual, I am the author of a bill, AB 1517, as was just mentioned, is on the governor's desk right now. We don't have a signature yet, and we'll talk about that in a minute. And my original intention with the bill was to, in a way, mandate specific timelines so that we could ensure that rape kits, that the forensic evidence from sexual assaults was tested in a timely manner, that it left the evidence rooms, went to the crime labs, and got into the CODIS database in a timely manner. Now, in California, due to a variety of initiatives and other legislation, if we, as the state legislature, were to set specified, require the local government to do something, they could then in turn argue that that was a state-created mandate, thus the state must bear the full cost. And as due to our budgetary issues and just in general, the legislature and the governor are loath to put us in a situation where we, the state, would bear the entire cost. The bill is now suggested timelines, but it allows for a jurisdiction, whether it's a county or a city, to mandate those timelines, to make them required. Let me go to the next slide. I think we've already heard the issues of we don't know, either throughout our state or across the country, how many of these sexual forensic evidence kits are sitting in property rooms. We do know, as was already stated, various places where they actually looked, they found huge numbers. LA County, for example, found more than 12,000. They have now mandated universal testing of their kits. San Francisco discovered just a couple years ago several thousand. They have not yet mandated the testing, but they're going through that. They're going through that process at the moment, but I don't think they finished their backlog. Alameda County did an audit after seeing our DA in Alameda County, which is the county I reside in. After seeing all the press about this issue and the fact that there didn't seem to be any real data on backlogs, she decided to take it upon herself and get various of her staff to visit the property rooms of all of our law enforcement agencies throughout Alameda County, and they found 2,000 kits. So, which she was kind of aghast. She had no idea that there was that number in our county. And as a result, she is the co-sponsor of the bill with me. Now, our Attorney General, Kamala Harris, took it upon herself to clear our state backlog. Now, if we go to the next slide, let's see, it's not listed here. In a few slides forward, it indicates how many of our counties, our smaller counties, send all their kits to the state lab. So the fact that that our Attorney General cleared the state lab made a significant dent in the backlog in California. So it is those counties that don't rely on the state lab that are still behind. Now, there were maybe a few counties that hadn't yet submitted their kits to the lab, but every county in California that had already submitted a kit to the state lab, which is under the jurisdiction of our Attorney General, Kamala Harris, she cleared that backlog. So as a result, we did increase the, we got a lot of hits. We've somewhat increased arrest rate, though we're still pretty low. So if you go to the next slide, you'll see what these numbers are in California. So currently, we only have about 23% of the rapes that are reported result in arrest. And as most of the people participating in this know, we already have a low report rate for rapes. Sexual assault crimes are one of the lower crimes that a victim reports even. So when you have those victims that do report to have such a low arrest rate is, quite appalling. And New York City adopted universal testing in 2008, prior to their adoption of the universal testing, their arrest rate was about 35%. Their arrest rate, once they adopted it, went up to 70%. So that's quite impressive. LAPD, as I mentioned before, LA did clear its backlog, now has the universal testing. When they did that, they tested 6,000 kits, and it led to 300 new arrests just from that action. So now we'll go to the next slide. That's slide 4. One of the things that our Attorney General, Kamala Harris, did was create a rapid DNA service. This may be in place elsewhere in the country. I know it's not widely utilized, but what it does is it includes in the kit 3 additional swabs, which are then sent directly to the DOJ lab for expedited processing. Because in many cases, the testing in the lab is in itself timely, or rather takes a long time. And so that's part of the problem of the backlog. And of course, the longer it takes, or the more steps that are involved in it, the more costly it is. So we were trying in California to bring down the cost, because that, of course, makes our bill easier to pass. Anything with a high cost on it is always looked at very negatively by our Department of Finance. So we wanted to try to streamline the process, and our Attorney General helped us by creating this rapid DNA service. And as a result of that, the process takes only 15 or fewer days, and this could be a great model for, of course, other states and the country. Now let's go to the next slide, slide 5. So now back to my bill. What 1517 does is it provides these specific timelines so that so here's the timelines that are in the bill. Once the assault victim or goes to the hospital and gets goes through the process of the exam, that the hospital would get the materials to the lab within 5 days. And that's for that streamlined program. Law enforcement would have 20 days to get the exam kit to the lab, and then the lab would process and upload the DNA profiles to CODIS within 120 days. I believe those are the same timelines that LA County is now using. So that's what we landed on. Now, part of why, as I mentioned, it's not a mandate is due to California's situation of the state having to incur all the costs if we mandated it. And secondarily, we designed this much in response to my bill to get this, to get these specific timelines is the 4th attempt that the California legislature has made. One previous attempt, the current governor vetoed because of law enforcement opposition, because sheriffs and others felt that it was too narrowly prescribed and did not give enough flexibility to law enforcement. Previous bills were vetoed by Schwarzenegger, I think one of them due to the fear that the state would incur all the costs, thus the mandate. So we designed this one in a way where we eliminated all law enforcement opposition and minimized the putting the cost burden on state only. Now, those of you on the webinar who have followed this issue nationally may have noticed that in many places, sheriffs have opposed such programs to get these kits tested. And it's been very, very unfortunate, and in different places the sheriffs have been very effective in killing these efforts, but we worked closely with the sheriffs this year. They don't love the bill, but we've at least got them neutral, so that gives us a much better circumstance to get it signed. However, it's not signed yet, and we've only got a few more days for the governor to do so. Let's see, what else was I going to add? the thing that I will wrap up with is a little a story, a real story, about a woman in Southern California area, a community in the Los Angeles basin, where, and this is just to demonstrate the importance of doing this testing very, very promptly. So this is a single woman who is living with a young son. She was awakened in the middle of the night by a stranger who raped her in her own home. She went to the hospital, pursued the sexual assault examination, and the detective on her case was sent the material to the crime lab. The crime lab informed the detective it would take at least 8 months to analyze that kit. The detective felt from the MO in the crime, from his observation of similar MOs, that this rapist was a repeat offender and that 8 months was too long to wait. So the detective personally drove the kit to the state lab. But unfortunately, at that point, still California's lab was backlogged and the kit sat for months. When it was processed, it did get a cold hit. And as a result, the rapist was identified. He was already in the CODIS offender database, but during the months that the kit sat on the shelf, the same rapist attacked at least 2 other victims, and one of those victims was a child. So that's, I think, we have many other true incidents like that we can report from all over the country, and this is why this issue is so necessary for us to get dealt with in a timely manner. And I'll conclude with that.
Thank you, Assemblymember Skinner, so much. Really appreciate you taking the time to be here, and it's really great to hear what's happening in California on this issue. So now, for both of you, for Assemblymember Skinner and Dr. Campbell, move on to sort of a question and answer period from participants, and maybe just a little extra discussion. The first question that I have deals with, so rape kits have multiple pieces of evidence within them, and it's asking for any background or success or challenges with implementing triage procedures for identifying what the best evidence is amongst a single kit, and only taking a certain amount of those samples and getting them tested. Do you have any background or history addressing that issue?
Well, I would answer this, Assemblymember Skinner, that this is what our Attorney General did with the Rapid DNA Service, the RDS, with the 3 additional swabs in order to get the DNA into the national database much quicker, and not to minimize the necessity of testing of other material that may be in the kit, but at least making sure to get some of that DNA as fast as possible into the national database.
This is Rebecca Campbell. To add to that, I would say that issues certainly come up quite a bit in Detroit, and the issue of getting into CODIS quickly, very critical, but when a case goes to trial, the prosecutors are going to need to be able to say, this particular biological fluid was found from this particular swab from this particular orifice. So I think it's a good question of, do you try to get that level of detail in the first pass? Do you go back and do follow-up work, additional testing, just for those cases that are going to prosecution? I think that the idea of trying to get some information quickly is important, but it does open up the need for some follow-up work for the cases that will be going to trial.
Yes, and our intent in California is not to have the RDS replace the full testing, rather to facilitate DNA getting into the database quickly.
Exactly.
The next question we have is sort of along the same lines in terms of figuring out appropriate ways, and I know that Dr. Campbell, you talked about this a little bit before, I guess triaging or figuring out if you do find a massive untested sexual assault evidence, if cost is a consideration, how do you address, or what aspects do you think are better, I guess, to choose as criteria whether to test or not test a certain kit?
Well, I'll let the doctor talk about what to test or not to test, I'll talk more about cost. There are federal funds that were made available. Additionally, the President has included in the budget for this upcoming year additional federal funds for states and local governments that prioritize this testing. And it is one of the few bipartisan, it's one of the few things that Republicans and Democrats support. So I would be optimistic that once they do move on the continued appropriation, that it would be included. That will greatly assist those jurisdictions or states that have put themselves in the position to be able to move quickly on this testing. The other thing I would raise is that if we look at the cost of not resolving these crimes, especially in the repeat offenders, the repeat offenders create a huge societal cost for each crime that they commit. So in effect, the sooner we can pull them out of circulation, if you might want to refer to it as, then there is lesser cost. Now that's a harder one for any particular jurisdiction to budget singly. So of course we always debate the individual cost of the testing of a kit, but we societally overall save a great deal of money if we resolve these crimes.
This is Rebecca Campbell. In the Detroit project, we explicitly tested these issues of can you see differential rates of CODIS hits as a function of different possible prioritization variables, such as victim-offender relationships, stranger versus non-stranger, statute of limitations status. Are they expired or are they still within the statute? The quote-unquote seriousness of the assault in terms of injuries, weapon use, and the like. And I don't mean to be unnecessarily provocative here or frustrating to folks, but I am not at this stage allowed to disclose what the findings are. They will be released in early 2015. But this is, essentially a bit of a teaser to say we did empirically test those questions because we appreciate that there are a lot of complicated issues about what would you do if you needed to prioritize. So we deliberately tested those with a very complex statistical model that gave us some, I think, hopefully some very clear-cut guidance. But I think as Assemblywoman Skinner mentioned, there are very important reasons to test these kits in terms of public safety. We did see a very high rate of serial sexual offending in Detroit, and I suspect that as more and more jurisdictions are testing their kits, that's going to continue to become the national picture. So given that there are federal sources of funding available for testing, I hope that the question becomes more, instead of how do we prioritize some versus just a few, to how do we keep CODIS populated and how do we do right by these survivors who went through this exam and have the evidence tested.
All right, moving on to the next question. So I'm trying to figure out the best way to say this. There are when you're working to get these tested and actually have the samples tested at different laboratories and you want them uploaded to CODIS, did you find any challenges with getting with that workload being much? Did you diversify amongst different laboratories? The specific question we have is addressing in this particular state. There's only one CODIS lab available. So is there a way that so how do you deal with a situation like that? Can municipal labs become registered with CODIS, or how did you address those issues if that was a challenge?
This is Rebecca. In Detroit, the kits that we tested in the context of the NIJ-funded research project were outsourced to a private vendor laboratory that our state police forensic laboratory system had an existing contractual relationship. And they did that because then the existing laboratories, and we have a regional system in Michigan of approximately, I think it's 5 or 6 forensic laboratories, so they could continue to work on the current cases, because it can be very difficult for any laboratory system, be it a municipality, one affiliated with the police department, a statewide system like we have, to try to keep up with current cases as well as the old cases. So in our case, the old cases were outsourced to a private laboratory. The in-house people kept working on current cases. As Rich mentioned in his presentation, the Michigan legislature did allocate $4 million for additional testing of Detroit kits. So we've been able to send a very large shipment of the kits that we could not test in the National Institute of Justice project. Those were also sent outsourced to private vendor laboratories. In that case, we worked with 2 different vendor laboratories who again had organizational relationships with the State Police Forensic Science Division. I think that jurisdictions that have this problem are going to struggle with that issue, and I think that they will have to use solutions such as private outsourcing or working with some type of regional laboratory system to get the kits tested.
Member Skinner, do you have anything to add?
I think you covered it well.
Okay. Well, that does it for our questions. I'd like to take an opportunity to offer either one of you a last comment, if you like.
I'm fine, thank you.
Also.
Well, thank you both so much for participating today, and thank you to all the people that listened. That does it for us. My information's on there. If you have any questions, you can reach me at rich.williams@ncsl.org, and my name is conveniently Richard Williams. So, yeah, thank you again for participating, and have a great rest of your Friday.